Hi there, and welcome to Modern Law. This is Billy Tarasio, and today I wanted to walk you through a client orientation and our client engagement agreement, which is a little different than what you'll see with many law firms. So our client engagement agreement, you can get completely online, or you can get a paper copy. And I just wanted to walk you through how to do it. So you start here by pressing start, and you enter your name and your email. You click here to review the terms and conditions. And this is really important, and this is what I want to walk you through. So this is our client engagement agreement. All clients that work with Modern Law are bound by this client agreement, and we don't like to call it a fee agreement, even though it does include fees. It's really a client agreement. And this orientation video is about explaining our relationship with you and the expectations of what we need to deliver to you and what we expect from you as well. So you're engaging us for a family law matter, which includes any action in superior court or related to your order of protection. Now, you can always limit the scope, but when you enter into this engagement, you're hiring us for all aspects of your family court case. As we go along, we may very well indeed limit the scope. You may ask us to do less things than we might be able to do, and that is something that we'll talk about and that we'll agree on in writing. What we don't do is appeals, quadros, or tax advice. We're representing you, and the firm is representing you, and regardless of which lawyer is assigned to work with your case, you are engaging Modern Law, and that means I ultimately have responsibility, no matter which lawyer you work with, although you will be assigned a lawyer, and you will be assigned actually a pod of attorneys. So our attorneys work in pods. That doesn't mean you're double charged, but it means that two attorneys know what's going on in your case all the time. And this has worked out great for us, because not only does it create a lot of collaboration between our attorneys and more brains on your case, but also if somebody goes out with food poisoning or on vacation or maternity leave or anything like that, you've got somebody up to speed on your case. And we'll make staffing decisions to provide cost-effective and efficient results, meaning we use paralegals to do things that paralegals can do, and then we outsource things like creation of binders and exhibit trial binders to companies that can do it cheaper and faster than we can. We're always going to communicate those staffing decisions with you, so you always know what's going on. Your agreement with Modern Law and the representation of your case begins after you've signed this engagement agreement, you've paid the trust deposit and any fees associated with your representation, and you've discussed the client agreement with your assigned attorney at your initial meeting or strategy session. So you may have met with a non-attorney for a consultation or an initial meeting at Modern Law. Now you know that paralegals or certified legal doc preparers cannot give you actual legal advice. And in fact, if you want legal advice on this specific document, on your client agreement, then you are encouraged to meet with an attorney outside of our firm. But the beginning of your strategy session will be set aside some time for you to ask any questions that you've got about this agreement, or you can reach out to me with any questions you've got. You are going to discuss your particular situation with the firm, and we are going to undertake this matter and work with you to achieve your goals and objectives. So it's your job to determine what it is you want out of your representation, and it's our job to advise you as to the tactics that are available to us on your behalf. And then you can make decisions on whether or not you want us to use any given tactic. For instance, we may want to do a deposition in your case, or we may decide that that's not worth it. So that's something that we're going to talk about all the way. And while you decide exactly what your objectives are, and it's our job to fulfill those objectives, there may be things that we have to do in your case. For instance, sometimes we have to file a notice of appearance, and we have to file a motion to withdraw. So when things are optional, we'll let you know, and you'll make the choice. When things are not optional, we'll just have to do them. And this client agreement means that you understand that. Sometimes we're going to have to take action on your behalf. What are your costs, and what can you expect to pay? We bill in accordance with the ethical rules of professional conduct under 1.5, which means they have to be reasonable. Now, that's not all that helpful to you, but here's what you can expect. You're going to deposit money into a trust account, and we're going to invoice you twice a month. So 2 times a month, you're going to know exactly what's happened in your case. You're going to be assigned an attorney, and that attorney will have an hourly rate. It's somewhere between $250 and $425, and we will let you know exactly what your attorney's hourly rate is. The paralegals bill their work at $150 an hour. And legal administrative work is billed at $100 an hour. That might be things like scanning or creating a client file. Rates may change from time to time, but we will let you know in advance. And truth be told, we very rarely raise costs on our clients. But what we do is after your matter is closed, we will close out this engagement. And if you come back to us for another engagement, then we'll redo and reopen our client agreement. So most often for modern law clients, that's the way that any fee changes would work. And it's extremely unlikely that your fee would be changed during the course of your representation. I suppose if you were a client of ours for 6 years straight, that might be a possibility. But honestly, that's the only time that might happen. We do some things on flat fees, and that includes petitions, responses, minimum charges for motions. Discovery requests are $400. That's $200 for the request for production of documents and $200 for the uniform interrogatories. Now, those are optional documents. And your attorney is going to advise you on whether or not that's a good idea in your case, whether or not it's crucial to your case, or whether or not it's completely optional and up to you. We also recommend basic estate planning and updating powers of attorney and charge $500 for that. That really protects you just in case you were to become incapacitated during your divorce. Someone would be able to work on your behalf that's not embroiled in litigation with you. Only very specific items are billed at flat rate. Everything else is billed on an hourly basis in 1/10 of a minute increments. That means if we talk on the phone for 5 minutes, it's 0.1. If we talk on the phone for 10 minutes, it's 0.2. So 6 minutes is a 1/10 of an hour, and that's how we do our billing. There are many times that we might talk on the phone and not bill you because we don't bill you for things like billing questions or purely administrative matters. But if we're talking about your case, if we're working on substantive issues, then we will bill you for that time. We will also pay costs for your case on your behalf. Things like filing fees to the court or paying a process server to serve your spouse if we have to do that. Those are things that we will go ahead and pay for out of your trust account on your behalf, and you'll see that itemized on your invoice. We're going to have a specific deposit for your case. What kind of retainer do I need to pay? Well, we'll let you know exactly what that is for your case, and we're going to hold your funds in a trust account on your behalf. We also require that a credit card is on file, and we require a minimum $1,000 balance in your trust account. That means if your trust account falls below $1,000, we will charge the credit card on file in order to bring it up to that $1,000 balance. If you have questions about that or you need to change your card, let us know. We do charge interest on unpaid balance, and the accrued interest is 1.5% a month or 6% annually. One of the things that we're very cognizant of is the fact that every single person has a budget. So we're going to talk about that, and we're going to be really honest with one another. If you find that you can't afford legal services, you're going to let us know. And what we do is we promise to work within your budget and see what creative solutions we can come up with. If you're out of money for legal services, perhaps our sister company, I Do Over, can help you. Or perhaps we need to withdraw as your attorney of record and work and do legal coaching behind the scenes. Whatever it is, it's very important that you're honest with us about money, and we're going to be honest with you about money. And the way that we do that is through invoicing twice a month, accurate bills. So our lawyers and paralegals track time as they go. You're not going to see inflated time charges. And at the same time, we do require that you communicate with us so that we can do the best job we possibly can on your behalf. Once your advance deposit's made and the agreement is signed and we've gone over this client agreement with you, we can begin. Your trust account must be fully funded 30 days prior to scheduled hearings, or we may not be able to represent you. Your information is confidential, no matter who is paying the bill. If someone else is paying for your representation, that's not unusual at all. However, they're not entitled to information about your case. And if you decide that you want us to give them information about your case, talk to your attorney about the pros and cons of that decision. So many times third parties are involved, but there are risks to you if you choose to do that. So let's talk about it. We may have you sign a waiver, and that waiver allowing us to speak to a third party is always waivable by you. So let's say you enter into a waiver and you say, yeah, talk to my mom, it's no problem. And then somewhere along the road, you decide, oh, I don't want you to talk to my mom anymore, or I want you to talk to my mom about fewer things. No problem. You just let us know. We store our client files in Box.com, and Box adheres to the highest industry standards for security, so you can share, access, and manage your content with confidence. All files uploaded to Box are encrypted at rest using 256-bit AES encryption. For files in transit, we use TLS 1.2 encryption. All that to say, your files are secure, and in fact, more secure in the cloud than they could be or would be in my office. But if you have questions about that, let us know. And that brings me to the next point. We recommend that you look into getting a safe and secure email address that maybe you use separate for only your divorce. This way, you make sure that no one else has access that should. And this is also a great time for you to think about changing all of your passwords. Maybe during your marriage you used or shared passwords and you used a similar password for a lot of things. It's time to go through and make a list of all of those different places where you have confidential information and think about changing your passwords. You want to use a private email address for communications with your attorney, and your work email may not be strictly confidential. So your confidentiality may be compromised if you're using anything other than your personal private email in order to communicate with modern law. We also have a client portal for you that you can use through our practice management software, Clio.com, and we'll have that set up and available for you to use. For modern law, we'll provide you with an electronic file once your case is closed. We do not keep your original documents, so we will scan everything and return it to you. We try to do that while you're here in the office, but if we can't do that, then we'll mail everything back unless you tell us to destroy the documents. Okay? We don't keep any of your hard copies at all. Now, any emails that we email to you will not be part of your electronic client file. You'll already have a copy, so that make sure to keep those for your client file. And we ask that you download your complete file from Box within 2 years of receiving your file. So we'll store it for 2 years, but at that point, you have to make sure to go ahead and download it and keep it safe. No settlement in your case will be entered into without your approval. Every single settlement offer that we receive, we will bring to your attention. We will talk through with you, and you will get to decide whether or not you want to do that. In order for us to do a great job, though, we need all of the information that you have. That means we need you to reply to emails, reply to phone calls. If you ghost us, we will likely continue to try to reach out, but eventually we will withdraw. And that comes down here. Now, at any point in time, if our relationship is going poorly, you are entitled to terminate representation, and we can do the same. Now, most often the way that that looks is if there's a fundamental breakdown in communication, or you're very frustrated with us, and we can see that you're very frustrated with us, we're going to have a conversation with you. And if that is not something that we're able to solve together, then we're going to recommend that you find another attorney, because the attorney-client relationship, especially in family law, is so intimate, and it's so crucial that there's trust and mutual understanding. So having a good fit is really, really important. So if you're dissatisfied or you have questions about fees or billing statements, please let us know promptly and work with us towards a resolution. We will retain the option to terminate representation at any time upon written notice, subject to our ethical obligations. So we can't withdraw right before a hearing unless you tell us it's okay. Now, any fees that we've earned, you'll still need to pay even if we withdraw. So if you owe us money at the end of representation, you're still responsible for those fees. One of the things that we do is if there is a fee dispute, we always try to settle it between us, and we ask for your cooperation in speaking with us and communicate about any problems you've got with the bill. And then we want to work together to solve that problem. If we can't, then we do agree to use the State Bar of Arizona Fee Arbitration Program. Okay, and if you fail to pay fees, that doesn't count as a dispute, and we reserve the right to collect those fees that you owe us. How do we collect unpaid balances or fees? If you fail to pay your fee or expense, we may seek collections, and if that occurs, there could be additional costs to you, interest, and maybe attorney's fees. You agree that you're responsible for the fees, and if you have questions, you will let us know. Any modifications of one provision in this agreement does not make the entire agreement null and void. And this is the entire agreement that we have, the client agreement between us. This is a relationship, and we're going to invest in our relationship with you, and we expect that you're going to invest your relationship with us. So be honest with us. We can't fully represent you if we don't know what's going on. Be responsive to us. We know that you want us to be responsive to you, so we need you to be responsive as well. There will be times in this representation where we need information that you have, and we're going to set up a file for you to upload your documents securely using box.com or the Clio client portal. Either way, we're going to try to provide deadlines, and if you could do your very best to comply with those deadlines, that will make our representation that much better. If you've got specific questions on this client agreement, make sure to ask your attorney at the beginning of your strategy session. Okay, so after you've gone over those terms and conditions and made sure you don't have any questions on that, you go ahead and click this box and click next. Your advanced deposit amount is going to be here. It might be $5,000, it might be less, it might be more. It really depends on your case. Next, you understand the rates. The rates are $100 for an hour for administrative work, $150 for paralegal work, and anywhere between $250 and $400 for attorneys. Here is where you authorize us to maintain a minimum of a $1,000 balance in your trust account. Go ahead and sign here. And, all right, it won't let me move on. And then this is where you pay. So click right here. And this is LawPay. It's an absolute secure place where you can put your credit card information in order to deposit that trust amount. So if it's $5,000, we lost the light, then you go ahead and put $5,000 here and send it in. Now, if someone's paying on your behalf, you can send them this link right here. You can just copy and paste that and send that to them, or we can send them a separate agreement that lets them know that even though they're depositing money on your behalf, they certainly don't have any access to your private information, and we can send that to them, or you can. Either way, we really look forward to working with you.